Hello everyone, once again welcome to the YouTube channel of Get Set Law by IMS. My name is Siddhant Singh, and as guys you can see it over here that this is something related with CLAT 2025. Yeah, exactly. So IMS Get Set Law is starting up with its new series, that is Best of CLAT, where we will be providing you for what has already happened in previous CLAT since 2020 till 2025. So to start with this, we have decided to come up with a solution of the CLAT 2025 paper. So previously it was not there on our YouTube channel because we were waiting for the final answer key. That definitely came in the time, that was in the month of December itself, but as you guys know that it was altogether of 3, 4 and even 5 months have altogether taken, and in the month of May they finally came up with the final answer key. So keeping in mind that, starting with this series, first I am over here to take up you guys over the CLAT 2025 legal reasoning paper. So you can consider this particular video as a video which is we are taking up the previous year paper, but with the solution. It's not only a solution, a proper explanation to this particular section which is going to be there, what topics were there, what were the total number of questions were there. So I would request all the students to watch this video till the end. If you are watching this particular video at a normal speed and you want that it should be at a higher speed, I would recommend you to go and switch it to 1.25x so that you complete the video but watch the video till the end. And also for the viewers who are there on our YouTube channel for the very first time, don't forget to subscribe to our channel, and if you have any doubt related to the question for the answers which have been marked over here, please drop into the comments and let us know. So let's start the video.
To book a free one-on-one law counseling online or at any IMS center, check out the link in the description box or the pinned comment below.
So as I have taken up over the summary over here before starting up with the entire legal reasoning paper, we have already taken up the entire analysis of the CLAT 2025, but coming to the part that what exactly it is. So just to tell you people that there were multiple sets, I think there were 4 sets of the paper. I am taking set A as a reference, which is marked as the asterisk one, the star one which was marked over here. So I'm taking this as a reference. So maybe you might have section B or section C where you must have taken paper from any bhaiya didi and must have been studying from that paper, must have downloaded it. And if you need it, we have already provided the link in the description. You can download that particular entire set, and the final answer key is also there. So there were in total 6 legal passages. First 2 passages comprises of question, the total number of questions was 6, so 12 in total. Then the remaining 4 passages comprising of 5 questions each, that is 20. In totality, there were 32 questions which were there. So we have already been taking 32 se 34 ke beech mein, that's the range which can come for the legal reasoning section. So that is what has happened. So the first paragraph was on given on the children and criminal justice. Second one, environmental protection, article 21. Now as you can see, the topics are there. The topics are going to be taken up in the paragraph, so nothing to worry about it. But that's the summary which you can see. Now the good highlighting part over here is, as you can see the word limit over here, the 2 paragraphs are less than 300 words. But when you will go to the consortium's website, they say that the word limit would be near about 450 words. Okay? So that is where they have kept the limit of the words at less. So that means this was a speedy section. So I personally have went through the legal reasoning section. मैंने खुद solve किया था CLAT 2025 वाले exam में. So in that thing I have also realized that the paper was a bit on the easier side, but somewhere it became a moderate. And there was one question which was even raised concern where there was a debate. So what that question is about, that is there. Okay? And also one thing to note, that section A mein the numbering of the question will going to start with question number 53 to question number 84. I hope that everyone can see the footnote which is being written over here. So, and starting with passage number 10. 10 means the Roman 10 se passage chalu hoga in set A. That is what you guys need to know. But मैंने इसे 1 से लेके 32 के बीच में I have kept the range. चलिए. So let's start with the first paragraph. So the first paragraph is talking about, as the topic was, children and the criminal justice system. So it says that children come in contact with the criminal justice system either as victims or the witnesses to a crime or as a children in conflict with the law, that is CICL. So we'll understand what is CICL. They say that children whoever come in contact with the crime, so there are few kids who comes in contact with the crime, so they might be a witness or they might become victim. Victim means वो उसका शिकार बन जाते हैं, that is what is there, ठीक है, to a crime in conflict with the law. As CICL, they could be alleged of, or मतलब उन पे allegations could have been be accused or recognized as having broken the law by committing a particular crime. So they are breaking the law as per CICL. They are saying that the children are breaking the law and they could be taken up for that particular crime. According to the National Crime Records Bureau, that is NCRB report, in the year 2021 they have launched the report. They say India recorded a total number of 1,49,404 instances of the crimes against the children in 2021, a rise of about 16% from the previous year. Now as you guys can see that I am not marking the entire portions, and even though I am explaining, so that may be the reason I am putting up the lines, but it's a very, very genuine suggestion. Whenever you solve your mocks offline, please don't scribble the entire paragraph, rather than try to put up a box like structure this, so that whenever you revisit the particular paragraph, your eyes are going to be on that part. This is a suggestion which I want all of you to follow. Chalo. So in terms of the percentages, that is 16%. The top categories under the crime against children were kidnapping and abduction. So now under the 16%, the highest percentage of kidnapping and abduction, followed by cases registered under the POCSO Act. Further, the NCRB report revealed that of the total cases, 53874 were registered under the POCSO section. Sexual offences against children shows a steady ascent with 4721. So now they are saying that the majority portion was of kidnapping, abduction, and now they are breaking it into part, that 50,000 around were registered under the POCSO sections, 47,000 around were cases recorded in 2020 that was in related to the sexual offences. Okay? So one is a which is related with the POCSO section, sexual offences which were recorded in 2020, and 47,000 around in 2019. Now in 2019, as many 32,000 cases were registered under the country, while 2021 report registered a decline of 3.5% recording these many cases. That means they are just breaking it down, what has claimed in the report in the year 2021, usko break kiya ki in 2019 kitne cases hue the under the POCSO, under 2020 mein what many the cases under the POCSO sections that was claimed. Now it says that the criminal justice system of any country broadly refers to agencies of the government charged with enforcing law, adjudication crime, and correcting criminal conduct. What they are highlighting it over here, that whenever there is any criminal justice system, every country has this, what they say, it refers, they are being considered to be the agencies of a particular government which have been charged with what is their duty, that is to enforce a law, adjudicate a crime, and correct the criminal conduct. The main objective of the criminal justice system is deterrence. Now what does the term deterrence over here means? That is to punish the transgressors and the criminals and to maintain law and order in the society. So this is the main objective. That means definitely there could be a question in the paragraph in the upcoming questions. So whenever such thing comes, you need to understand the main idea निकालते कि purpose क्या entire इसका objective क्या, so clearly highlighted. These are the figures. Maybe you can just क्या बोलते हैं इसको, एक skim reading you could have done it, but in the entire paragraph where these terms comes, कि what's the objective, you would have properly highlighted. But highlighting not by a highlighter, it's not allowed. It's a blue or a black pen which you can use it. Okay, no pencils. Now globally, children and young people are routinely exposed to various forms of violence. If they are before criminal justice system, they are at risk of physical and psychological abuse, sexual assault, and other harms, including inadequate education opportunities. Now these are the various reasons on what the crime could have been done and the solutions to it, like providing some education opportunities, because there have been inadequacy or poor or outdated vocational training, and so is the reason these students, or not the students, these children have become trapped to these things. Now they say they face several challenges including mental, emotional, and behavioral disorders. Children who are victims of violence, exposed to violence during childhood, are more likely to have difficulty in the school, abuse, and so that means this is just a generic information which is being given. Maybe you have to go and refer to the paragraph in the near questions when you study. Now coming to the first question, as you see over here, the questions are majorly the one-liner based questions. One-liner means एक या दो line के questions थे, and options are also very less. So that's why even if you have spent time in reading the paragraph, maybe like 2 to 3 minutes, maybe 4 minutes, you could have solved the question in next 1-2 minutes. That means in totality you would have taken 5 to 6 minutes only. जब मैं legal reasoning section solve कर रहा था, I calculated somewhere around 25 से 28 minutes is the good time. Suggested time is 35 minutes. So 25 to 28 times entire section could have been solved. So chalo. So we'll start with the first question over here, which is on the screen. So after reading the entire paragraph, you must have understood what all meaning is being there. So let's move directly to the question. It says, which of the following issues children who are victims of violence during childhood face in life as per the author of the passage? Now you see the first question which is being thrown to you, which is in legal reasoning related to what is the author of the passage is talking about. So a lot of time these, and since past 2 years CLAT have been playing in the legal reasoning section also कि author क्या पूछ रहा है, which majorly comes in your English and the logical reasoning part. So they say they may have difficulties in the school, so definitely it could be the one. They may abuse drug or alcohol and suffer from mental health problems, so psychological problem is also there. They may act aggressively and engage in the criminal behaviors also. So which issue it's being referring to? It's all these issues which are there, so which makes option D, that is all the issues are there. So all of the above is the correct one. Chalo, let's move to the next question, which says, what is the primary objective of the criminal justice system as mentioned in the passage? So primary objective यहाँ पे क्या था? Is it rehabilitation? No. Is it reformation? No. Is it protection of victims from the offender? No, it's the punishment of the offenders, because if you go to the paragraph, so maybe options could have been up and down, it could be B or C, that you can just check it up in the paragraph. I just flipped it up, but the answer needs to be correct, that which says that option C is the correct answer, because the primary objective of this law which was given over here, the criminal justice system, is whosoever is doing this particular crime needs to be punished. You go in the paragraph, in the second paragraph you see the main objective part. Chalo. The National Crime Record Bureau, NCRB in India, is responsible for as you have seen it in the first paragraph, where ये जो National Crime Records है, इनका main aim क्या है भाई? Report generate करना. Report कैसे होगे? When you collect the data and preserving the data is not the one, you analyze it and then you publish that data. So compiling and analyzing the crime data is the one option. Conducting forensic investigations is not, it's not about investigation, it's about giving the report. Maintaining national database, partially correct, but it says fingerprints of the criminals. This is partially maybe the one, but they are majorly responsible in context with the paragraph. It's like they give, the NCRB gives the report कि किसका कितना crime है, 16% crime बढ़ा and so on. So that is compiling and analyzing the crime data. Next we go, which category had the highest number of cases under crimes against children according to the NCRB report 2021. अब इसमें when you go to the paragraph and refer to it, the majority one statement में खुद दिया है, go to the paragraph, check it up, that it is not related with POCSO or the sexual offences. These are there, 47,000, 43,000 is there, but the majority one is in line with kidnapping and abduction से related है. So as I suggest a lot of time that all of the above or none of the above could be the answer, but you need to always eliminate ones and see whether all the options are there. But they say which are the highest number of cases and which category, so we can't make it all because individual bifurcation is given. So kidnapping and abduction, again the options could have been a little bit flip, maybe a B could have been there in the paper, but you go with the kidnapping and the abduction part. Chalo, which of the following is the correct expansion of the term POCSO? Lao, POCSO का full form बताओ. Now this is related with children, so whenever there is women हट जाएगा. Criminals of sexual offense, it's basically related with children. It's not only the criminal one. Criminal comprise of everyone. So that's why इसका आंसर बन जाता है A, which is protection of children from the sexual offenses. Now it says, question 6 says, what risk do children face when exposed to criminal justice system as per the passage? Now they say vocational training inadequate है, paragraph के last part में दिया हुआ है. Exposed to risk of physical abuse is also given. Mental health challenges, psychological barriers, it's creating problem. So the correct answer इधर पे क्या बनेगा? D, that is all of the above. Question number 7, it says in which among the following changes were introduced for environmental protection through the Constitution of India, that is the 42nd Amendment Act. मतलब question क्या है? Among the following, in which the changes have been introduced, whether it was in the fundamental right, duties, or the directive principles, or any one of them. So we have clearly understood that it is your fundamental duty, right? It is the fundamental duties, तो उसी में change हुआ है. So that is where we will go with fundamental duty वाला option. That is something which is clear, and also it talks about that it is the duty of the state. I think it is duty of the state and its resident. So state की duty कहाँ होती है? Directive principle में, fundamental duties में. तो 2 और 3 वाला option कौन सा है? That is option B. So that becomes the correct answer. It's very simple, directly given from the paragraph. Let's go to the next one. It says the nature of binding commitment of India. Now what they are saying that whatever India have been doing, what is their binding commitment, is being to reduce carbon emission through signing of the various international environmental conservation treaties like the Paris Agreement, especially the Paris Agreement, which have been described as what? Now they are putting up a question ki what is the nature of this binding commitment of India? What is exactly there? Why India have become a signatory to this? What is the objective? What is the purpose? So the signatory shall take, so what the signatory is saying, what is the nature of this binding commitment? That is, signatory means India shall take adequate measures to reduce carbon emission. Okay, that is what is India has decided na? That is given, that we want to reduce carbon emission from increasing these degree, and this is what is there. The signatory India has binding commitment to reduce emission. देखो directly दिया, मतलब ये तो 8th 9th 10th क्लास का स्टूडेंट भी सॉल्व कर लेगा, ये तो गलत ही नहीं होना चाहिए, ठीक है. It's clearly given. The signatory may take adequate measures to reduce carbon emission. Now you are saying may take or shall take. Now is it a compulsory duty that India has binding commitment? So when we take binding commitment, they are going to take. It is not it may or may not. May means shayad. So shayad wala option never goes. So now you see only this change. This is what a confusion is created. So when we read the options, we need to read it very judiciously. That is one thing. Signatory should explore the possibility. No, it's a binding commitment. The signatory may formulate necessary policies. So it is again talking about करेंगे. But this makes it an option A. So I don't think that इसमें कुछ भी doubt होगा. ठीक है. Next say Article 51A(G) of the Indian Constitution. It is specifically mentioned that citizens shall have the duty to protect and improve the natural environment. That includes what? Now अपने को यहाँ पे clearly दिया गया था. It includes what? It includes ये सारी चीजें already included हैं. तो इसमें क्या option बनेगा अपना? That is in question number 9. It says that it includes rivers and lakes, all living creatures, and forest and wildlife. अब इसमें forest and wildlife में all living creatures तो आ ही जाएगा. तो can't we say that it is only option A and B? Because forest and wildlife definitely can come under the living creatures part. So अलग से C option mark करने की जरूरत है ही नहीं. So we will go with only A and B. Next we move towards, it says as per the aforementioned paragraph and decision of the Supreme Court, you need to decide which statement makes it a point. And this particular question was a question which raised a debate among the inference part. Why? Because what you are understanding from the paragraph, let's understand. Okay? So maybe the reason that you will go with any one of the option, could only one option be the answer or both the options, but we don't have such thing. Let's understand. First says कि Supreme Court का decision किसके around है. So let's again revisit the paragraph. It says builds on the bulwark of jurisprudence right to clean environment. This is what they are saying. Any disturbance with these elements will raise to violation of your right to article, and establishes a duty of the state to maintain ecological balances and also to prioritize environmental protection and to process everything which is right against the climate change. First, fundamental duty to preserve and protect natural resources upon the state only. No, सिर्फ state के बारे में बात नहीं कर रहे हैं. Citizens alone have the fundamental duty to preserve and protect the natural resources? No. क्योंकि when we say that there was an amendment which took into the picture, तो सुप्रीम कोर्ट ने तो क्लियरली हमारे आर्टिकल्स में मेंशन किया ना, आर्टिकल 21 की भी बात हो रही है, 51AG की भी बात हो रही है, 48A की भी बात हो रही है. So these options alone is eliminated. Both state and citizens have the duty to preserve and protect the natural resources. That is true. States' duty to maintain ecological balance and citizens' right against climate change. Now, after seeing both these options, don't you see that यहाँ पे state and citizen included है, यहाँ पे भी state and citizens की बात की गई है. That means both have the duty. इधर बोल रहे हैं against climate change, इधर बोल रहे हैं preserve and protect natural resources. That means क्या C ही आंसर है, और that means क्या D भी आंसर है? That was a debatable thing. So इसका दोनों आंसर C and D, that is what was there in the final answer key, which raised questions because people have raised the objection. It could be D also. By what reason you are able to eliminate it? Because the interpretatory part tells about both. Because we see it from the overall paragraph, we don't see only what is given in the last paragraph, we see both the parts. So that's why the students who are marked with C and D have been given equal weightage. Chalo. Last question for this paragraph says, according to the passage, what makes India committed to reduce carbon emission? Now it says, what has make India? So is it just the decision, the policy decision? Or, so I don't think this is the last question, I think this is second last question. So for 11th it says, being a signatory of international environmental conservation treaties, it makes India committed to reduce carbon emission. So they are asking ki, what is that act of India which is making believe that India is moving towards the carbon emission? So first, signatory हो सकता है, because of the Supreme Court verdicts which obliquely make way for an enforceable right. So now this is something which is a forceful thing rather than India itself believe. It is not because कि वो law में है, Supreme Court is pushing it, making a mandatory, that's why India want. So I don't think that option B could be the answer. Because of the policy decisions of the government, so it will never go, anything will never going to emerge from a country because it is a mandatory rather than it is on the generic way also, and India has committed itself, they itself have binded. It's not because of the government, because of the Constitution of India 47 amendment, this to came later on. India तो पहले से ही part बनना चाहता था, and that's why they become a signatory, and that's why they want 2030 2047 तक changes हो. So that's why signatory clearly commitment दिखाता है that we want to reduce carbon emission because other 196 countries are also doing the same thing. So it's not because of the constitution or the law or the government, it is because what everyone in the world who's living on this planet thinks about it. ठीक है. The last part, the passage mentions that any disturbance with these basic elements of environment would amount to right of violation of Article 21. Article 21 deals with, now guys, again this is a question, POXO का full form, यहाँ पे Article 21 का मतलब क्या है? That is what you need to say. So is it right to equality? No. Is it right against exploitation? No. Is it right to freedom of residence? No. Why these are no? You will tell me in the comment section ki which article talks about these things. By elimination, you will come to know that the correct answer is right to life and personal liberty. So while explaining it, I've already explained it before also. So that's why D is the answer. Chalo. Now we talk about the third paragraph. So the third paragraph says that about the Contract Act 1872. That means in the past 4-5 years, in the past 4-5 years, there have always been a balance of the current legal part and the static part. So majorly constitution, law of tort have been there. This year contract again came into the picture. In CLAT 2021, 2022 CLAT mein the contract law was there, but now this have again been there. That means contract law is gaining importance again like the law of tort. So this year tort didn't came. Okay. So now, so this is a static law. It talks about India, its rights, duty, exception arising out of it. Section 2H of the Act gives the definition of contract, which is simply an agreement enforceable by law. It says that a contract is what? Which is an agreement which becomes enforceable by law. Majorly static portion, so I'll just take it down very fast only. It says to understand the difference between a void agreement and voidable contracts, that is what the multiple sections they will mention about 2H, A, I, D, etc. 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 Okay, of the Indian Contract Act. Void agreements are fundamentally invalid making them unenforceable by default. Void means it has no legal relevancy, no enforcement can happen, no one can bring a case against each other. These agreements cannot be fulfilled as they consist of illegal elements and cannot be enforced even after subjecting to both the parties, because it has become void because of maybe not an illegality, because of some impossibility also it can happen. However, in case of voidable contract, the agreement is initially enforceable, but it is later on denied at the option of either of the parties due to various reasons. Maybe coercion, maybe time is the essence, within time delivery nahi kara. Now it's on the person whether they want to accept it or reject it. Unless rejected by a party, this contract remains valid. That is a voidable one. If the party is not saying no, I don't want to follow it, मुझे case file नहीं करना है, I don't want to follow it and I want to file a case, then it becomes void. But if it has not been rejected by the party, उसको वो valid मान लेंगे and enforceable हो जाएगा. That means voidable contracts can become valid, can become void at the option of the ones who is aggrieved. The party who is at the disadvantage due to any circumstances applicable to the contract has the ability to render the agreement void. That means it says that the party who is at the disadvantage, the aggrieved party, he has an option and make it a void. A void agreement is void ab initio, making it impossible to rectify any defects in while voidable contracts can be rectified. Now again a question to you people, what is the meaning of the term void ab initio? Drop your answers into the comments and let us know if you guys are revising or not. In case of void agreements, neither of the parties subject to any compensation for any losses, but voidable contracts have some remedies. So this is how they are balancing between void contract and voidable contracts or the agreements. But valid agreement, it forms a contract that may again be either valid or voidable. Primarily difference between a void agreement and a voidable contract is that a void agreement cannot be converted into a contract because it is not at all allowed in the legal sense, since it is from the start it's not valid. Okay. So this is what is, it's very basic. Someone who have studied the law of contract would have been able to do it in next 1-2 minutes, so it's very easy. Okay. Chalo, let's talk about question number 13. It says, which of the following best describes a void agreement? Now, void agreement में क्या होता है? Agreement is valid until declared invalid by the court? No. ये पूछ रहे void agreement क्या है? Void agreement means that has no legal effect from the beginning. Okay. Agreement that is legally enforceable is a valid contract. Agreement that can be enforced if one party chooses to do so is voidable. So correct answer is option B. Very easy. Next we move towards a contract between two parties to rob a bank and share the proceeds equally can be termed as what? Now this has some illegal intent over here, illegal element. So correct answer would become a void contract, क्योंकि voidable नहीं है, because from the beginning the element that is an illegal part which I clearly mentioned na, the party who's at a disadvantage, no, this is the illegal part. इतना ढूंढना becomes a difficult while teaching. हाँ, the agreements, these agreements, that is the void ones, cannot be fulfilled as they consist illegal elements and they cannot be enforced even after subjecting it to the both the parties. So यहाँ पे भी subjecting to both the parties मतलब voidability के category में नहीं आएगा, void में आएगा, valid था ही नहीं, legally enforceable भी नहीं था, so void contract हो गया. 15. An agreement made by an adult but involving a minor child, where the signatory is a minor child himself, this agreement would be. Now the question comes, there is an agreement which is made by an adult. Okay? So maybe the reason that it has some validity, maybe the reason because it is made by the adult, but he is involving, when we say a contract, an agreement made by an adult, but he is taking a minor into the part. So making a minor participant to a particular agreement makes it a void. So initial part makes it valid. It may become void. It could be. So that is what we need to understand in context with the paragraph. It says it is valid or void. So it will become a voidable agreement. But a lot of students have went with option C, which say that, sir, since minor is there, then it is a void agreement. It's not that correct. Okay? So that is where the interpretatory part comes into the picture, that how well you have understood the paragraph and your knowledge about it, because you need to read the question properly. Like in the previous question, it says rob a bank and share the proceeds. Rob a bank, outrightly illegal. It can't even made a validity part. ठीक है? It could have been something else, then शायद वो valid void पे आ जाता. But over here, agreement made by an adult involving a minor as a signatory, valid void both. That's why the answer is option B, not C. This is a debatable part which happened, but consortium has not accepted the objection and they went with option B. Now for 16th one, which of the following scenarios would most likely result in a void agreement? So for such question when they come, we need to read all the options. It says agreement signed by someone under duress. So duress means a pressure, a coercion. So this makes a voidable contract. So you need to understand this by the examples only. A contract with mutually agreed parties to terms to sell the house. It is not a void, because to make it a void we need to make it since the beginning part itself. Then we say agreement to pay 10 lakh on getting a government job. Now there is an illegal object which is something going against a public policy, that you can't get a job, you can't clear CLAT exam if I'll say pay me 1 lakh rupees, I'm going to get you exam clear. No, it's always the efforts, the passion which you guys follow. So that's why the objective behind this is something making it is wrong. A contract with minor who understand the terms. So he is a minor but he is able to understand the terms. Maybe again a debatable, but he might be a beneficiary. That means he's not a party, but there is a minor who's part of a contract, can be a beneficiary also. There is a loophole. Then in that case, D can't be the answer. The answer would be C, because it is outrightly making it a void agreement and we need to see that it is from the start or not. Okay? So that is what is there. The last question for this one is, an agreement made without consideration is generally, so we know consideration is one of the element of a contract and it makes a void agreement. So it does not talk about voidability, enforceability and valid. Since valid nahi hai to enforceability nahi ho sakta. That's why we'll stick to till question number 17 only. Now as we move ahead with this paragraph, that is, I think this is the fourth paragraph which is coming over here, but the paragraph length you can see, as I mentioned, below 300 words in the initial part only. So this is in regard with the GI tag. So when you have studied the IPR laws, this became a relatable part. So let's understand. So geographical indications are a form of intellectual property that designates a product as originating from a specific geographical location. Nagpuri oranges, Kanjipuram silk sari, right? Then Kolhapuri chappal. That is how it comes. Where a given quality, reputation or other characteristic is essentially attributable to its geographic origin. GIs protect names that are used to identify products with specific qualities or characteristics due to their geographic origin. For example, they say Champagne refers to sparkling wine produced in the Champagne region of France. Darjeeling tea refers to the tea grown in Darjeeling region. The protection of, now they talk about that these GIs to be protected to ensure, now what's the objective? To ensure that only products which are genuinely originating from a specific region are allowed to use these geographical name, else it will be violative of GI tags. This helps to maintain the product's reputation, which they mention, quality, reputation, everything, and quality, prevents misuse of imitation and supports local economies by promoting regional products. Local economies means the local vendors. Now they are preserving their own product, it's a cultural thing which comes, right? That is where they talk about northeastern part mein, there is a multiple way, like wahan ke momos, it becomes very special, hai na? But have they got a GI tag or not? That's a different question. Okay? Now promoting so that's the promotion part which they talk about. International agreements such as TRIPS agreement under the World Trade Organization provide a framework for protection of the GIs globally. This is what was there in the paragraph. Let's directly move towards the question. It says, which of the following statements about geographical indication is not true? That means, so whenever such question comes, what you need to do? You need to understand whether it is saying false or true. It says, which of the following statement is not incorrect? That means they want to tell you, or they want to ask you which one is correct. That's why it is. Okay. Now we say that GIs are protected under international law. This is true. It is asking not true, so this is wrong. Use of GIs can be legally challenged if it is used by products not originating from the specified region is also true. That's why it's wrong. Geographical indication GIs can be used to any product which is licensed regardless of the place of origin is false. That's why the correct answer is option C. That's absolutely given. Now we see D also. The TRIPS agreement under the WTO establishes a framework for the protection of the GIs on a global scale. This is also, that means this is also true, but over here it will not going to be the correct answer. Chalo. 19. It says if a product named Darjeeling tea is produced outside of Darjeeling region, we need to understand properly. Na? What the question says that Darjeeling tea is produced outside Darjeeling region. Which of the following legal actions is likely to be taken under the GI protection laws? The product can still be sold but with a disclaimer about its true origin. It can't be because it says now, because you need to take up a legal action. If it says the use of GI name can be legally contested and potentially prohibited, because if you want to produce and sell it, don't use the term Darjeeling tea. That means you are not the producer. You can sell it by buying a Darjeeling tea and tell it that it's a shop from Darjeeling which is selling, then it could be protected. So it says that the product can still be sold with a disclaimer about its true origin, but you can't produce. That is what it highlights. So that's why option A is not wrong. B could be the answer. It says product can be sold under a different GI name, not Darjeeling tea. This is a suggestive option. We're not going to go with this. The product can be marketed as Darjeeling tea and will face no legal consequences. Now, as clearly stipulated in the paragraph, that if you are particularly, it should have a specific geographical related to the quality, reputation and characteristics attributable to it. They want to maintain this, they want to promote regional products, and it is not allowed to use the geographical. Only they are originally originating from that region can only use. Don't use the term, they say, Darjeeling tea until and unless the people who are producing, but they say na that if the product name Darjeeling tea is produced outside the Darjeeling region, how it is possible? This is something violative. So option B is the correct answer. Let's see. Which of the following, next question, which of the following is not a potential consequence of the misuse of geographical indication? Now we need to completely understand the question, which says it is not a potential consequence which can't be taken under the legal action. So it says loss of consumer trust is the authenticity of the product. So is it a consequence? Yes, it's a consequence. They are asking, not a potential consequence of the misuse. Okay? So A is a consequence. B, decrease in the market value is a consequence. Compulsory license on patents of misusing entity. Now this is out of context, so maybe not a consequence because it's talking about the patent and GI tag. So correct answer becomes C. That is out of context. Potential legal action of infringement against the misuse is again a consequence of misuse. Chalo. 21st. In the context of GIs, which of the following scenarios best illustrates the concept of geographic origin? We need to understand that which of the following is illustrating. So product's name is changed to reflect its local ingredients rather than its place of production. This is wrong because it is not illustrating the concept of geographic origin because you are changing the production. A product is marketed with a GI name even though it is produced in a different region and country. No, you can't use a GI name. That is what is where the law is protected. So this is wrong. A product is identified by a GI name that corresponds to the region where it is traditionally made, cultivated with distinctive qualities due to that location, makes it a comprehensive option, which is altogether a right. Why? Because they are saying, ma'am, you are selling a product which is identified by a GI name like a Darjeeling tea, corresponds to the region where it is traditionally made, cultivated with distinctive qualities due to that location, and if this context of the GI origin is given, it is really defining that thing. A product is sold under a generic name with no reference to its production is outrightly wrong because it is again a consequence. So the answer is C. Next, choose the most appropriate objective of the TRIPS agreement concerning geographical indication, which was under the WTO. Okay. So it says to harmonize intellectual property laws across member countries. So is it only in this context? That is what the TRIPS agreement talks about, or they want to provide a proper framework? That is what was given in the paragraph. And it is saying intellectual property laws. Now this is a very wider option in context with concerning geographical indications you need to answer. So this is widely accepted option, but not the option in this context, to ensure uniform product labeling standards globally. Now it's not only about the labeling, it's about the quality, it's the product, it's their own culture which they want to protect. To provide a framework for protection and enforcement of the geographical indications, outrightly correct, and completely to promote international trade by standardizing. So these all are generic and the wider ones. That's why C is the correct answer. Let's go to the next paragraph. Now this paragraph is in context with some examination where I think it was in context with the UPSC, some cheating mechanism, unfair means which has happened, and that's why this actually came into the picture. These rules were already framed and have been implemented, but this was very much needed, which happened in the year 2024. So let's understand. The Public Examinations Prevention of Unfair Means Act 2024, that has the provision for up to 5 years imprisonment and a fine of rupees 1 crore for malpractices and organized cheating in the government recruitment exam was notified by the union government, came into the effect on June 2024. Bill got the assent from the president and all these things came into the picture. Now this mentions punishment for leakage of question paper or the answer key, directly, indirectly assisting. Now this is again direct or indirect assistance the candidate in any manner unauthorized in the public examination, and tampering with the computer network or computer resource, hack whack karna system. These are considered to be offences done by a person, group is also included, or any institution who is engaged in this. So there have been multiple cases related to cheating, unfair trade, unfair means or the unfair practices which have been done by the people under the cheating of the UPSC exams and the other banking exams also. So that's why this was there in that year. Besides these, creation of fake websites to cheat or for monetary gain, conduct of fake examinations, fake admit cards, offer letters, monetary gain, manipulation in the seating arrangements, allocation of dates, shift for the candidates. These all are the means which are clearly defined as the offences punishable under this law. This is what the entire offence and the penal provisions being given. Let's go to the next paragraph. Say any person or persons resorting to unfair means offences under this act shall be punished with imprisonment for a term of not less than 3 years, but which may extend to 5 years, and with fine up to Rs 10 lakh. That is what is given in the act. So this is what have been done if he is resorting to unfair means and offences under this act. If he is coming under this provision, ये सारे offence अगर वो कर रहा है तो 3 years से 5 years तक का हो सकता है along with the fine. A service provider engaged by the public examination. So service provider, एक example if I'll tell you, that TCS majorly assist in conducting a lot many online exams. There are multiple other platforms also. So could be a service provider which engaged by the public examination authority for conduct of examination shall also be liable to be punished with imposition of fine up to rupees 1 crore, and proportionate cost of examination shall also be recovered from it according to the act. Such service providers shall also be barred. Now they will also be stopped along with the fine. They will be stopped from being assigned of with any responsibility to conduct any of the public examination for the period of 4 years के लिए complete bar लग सकता है. So as we see the entire paragraph, the understanding from the act itself clearly defines. Now we see, sir, we have never studied about it, okay, but can't you generically read it? Like if the aspirants who are in CLAT 2026, 27 students are watching this video, don't you think that it's a very generic article which may come in the newspaper also? which might have been there in the newspaper, you come across, now you have some knowledge about it. But you must have not read the paragraph, but when you read it for the very first time, don't you guys believe that it is actually easy to understand the definition, the meaning, the terminology? These are very, very basic. So I believe that this is not a very difficult thing, which if also comes into your exam also in CLAT 26. Chalo. The question comes, a bill becomes an act only when? Now this is a question which I think 100% of the aspirants who are not even the lawyers, any generic person also can definitely say, when we get the assent from the president, that is where a bill becomes a law. So let's say, what could be the answer? It says both the houses of parliament passes with a simple majority. Now this is where some knowledge which you need to apply and go for it. But is it just the house with a simple majority? The last part is the assent to be given by the president. Okay? Both the houses of parliament with absolute majority, when the Prime Minister of India gives his approval, or it's the President of India gives the assent. That makes it a correct option. So that's why it's D. No explicit explanation is needed. Now it says, a service provider engaged by Public Examination Authority for conduct of examination indirectly helped his family member by giving hint on questions that were supposed to be asked in the examination shall. Now by reading that question, we don't know that what would be the options. So will he be liable, will he not be liable, or liable for what? So now all options talks about liability. That so one thought gives to your mind that the answer is about liability, we know it, but now we need to check whether the liability is as per the information in the paragraph or not. So it says, with imposition of fine of rupees 1 crore, fine of 1 crore, will be punished with imposition of fine up to 1 crore. So what does it say? The service provider. Let's go to the paragraph. Oh, we came back. Let's go to the paragraph. It says that service provider engaged in the public authority for conduct shall be liable, punished with imposition of fine, and proportionate cost of examination shall be recovered from it. Now there are two things. So when it says the punish imposition of fine, this is partially correct, 50% right. Liable to be punished with imposition of fine up to 1 crore and entire cost of conduct of the examination. This part is not the and one. It was a proportionate cost. So whether all these options talks about liability but does not gives a direct meaning. So as I have already explained, when we have all of the above or none of the above, that could be the answer. And for this, the answer is none of the above. Why? Because this is partially correct. It meant it's not only 1 crore. Halfway knowledge nahi lagayenge. We will put proportionate cost bhi dena tha, which was there in the paragraph. Again, I'll take you back to the paragraph. It says, and proportionate cost of examination shall also be recovered and will be barred later on. Okay? According such service provider shall also be barred. So all these information not given, that's why we'll go with option D. Chalo. Next we go to question number 25. It says, an invigilator of a public examination found guilty of manipulating the seating arrangement to favor his relative writing the public examination is punished by the court. Who? That is an invigilator. Which among the following is the appropriate punishment as per the punishment mentioned in the above paragraph? So an individual will going to be held liable for what? If say it is for 1 year, no 1 year to tha hi nahi. Is it for 2 years? 2 years bhi nahi tha. Is it for 3 years? It was 3 years, but usme was the maximum it can be taken up to 5 years. That is what was given. So 3 years से लेके 5 years तक का था. So we can say कि ये 4 years भी हो सकता है. But ये जो fine of 15 lakh है, तो half way it was correct, half way it was wrong. So I think इसका answer भी come to option D हो जाएगा, क्योंकि 5 lakh का fine was only which was given. Let's go to the paragraph again. A person unfair means offences under this not less than 3 years, so 3 which may extend to 5, and fine up to 10 lakh. Up to 10 lakh. That means maximum upper cap is 10 lakh. So if we'll go to the paragraph, if we'll go to the question, it says 4 years, which is not absolutely correct, but it says maximum 5 years. तो 4 साल की तो imprisonment हो सकती है. and fine of 5 lakh that, because upper cap is 10 lakh. So that's why option D. Chalo. 26th. Which of the following is not an unfair means relating to the conduct of public examination? Coaching center conducting mock tests for students is not an unfair means. Coaching center offering help to students during examination is wrong. Help, what type of help? It could be any help, positive, negative, so outrightly wrong. Superintendent of the public examination on the request of the coaching center provides seating arrangement of all the students in one hall is also wrong, because related to examination you can't do. Or the center superintendent of public examination indirectly assisting the candidate is also unfair means. So the first one, when we conduct, like IMS conducts their mocks, and if you guys have been studying with IMS or have been studying with someone else, not access to our mocks, guys, please go and check out it. If you're already studying, take up our test series and go for it and check the mocks. Okay, chalo. So answer would be A. The last question for this: who among the following is not a service provider in context with the public examination? Now, I पूछे कौन नहीं है? Coaching center which prepares students for passing in the public examination is not a service provider. We are not service providers. Printing press where question papers of the public examination printed is a service provider. Software company manages website is a service provider. Company which scans the OMR is a service provider. So answer becomes A. Now coming to the question, the paragraph which is the last paragraph, and then we'll end this up. So but let's finish this up fast. So now the last paragraph talks about the Supreme Court of India declared that right to privacy is a fundamental right, and that right to information privacy is part of this right. So that is related with right to information part. Subsequently, Parliament of India enacted a new law relating to digital personal data protection. The new law applies to Indian residents and businesses. So it applies to whom? That is what is important. Collecting the data of Indian residents applies to non-citizens living in India whose data processing is in connection with any activity related to offering of goods and services that happens outside India. Now this is important point. What it says, it is applicable to the non-citizens. So it's clearly mentioned that Indian citizens पे तो applicable है, but non-citizens पे भी कि who is living in India whose data processing is in connection with an activity which is related to goods and services जो आप इंडिया के बाहर भेज रहे हो, क्योंकि बट आप तो रह रहे हो ना इंडिया में, तो डेफिनेटली आप पे भी applicable है. The law allows personal data to be processed for any lawful purpose. If the personal data is sensitive, then additional safeguards are to be. So this is important. Sensitive है, तो additional safeguard लगेगा. This is again important. That is why I am putting up boxes. I am not completely underlining it. The entity processing data can do so either by taking concerned individuals' consent or for legitimate uses, which includes situations where an individual has voluntarily provided personal data for specified purposes. What it says, whosoever is entity is processing that particular data can do so by taking the concerned individual consent. So whenever any entity is taking my data, they can further provide the data only when I have given consent to this part. ठीक है? Or for the legitimate use, which includes situations where I have voluntarily provided personal data. If I have given my Aadhaar, my number, mobile number, everything have been given, then without my consent they cannot make any other use. The law requires that an individual consent must be free, specific, informed, unconditional, unambiguous, with a clear affirmative action and for a specific purpose. That it should be clearly definitive. Like if I am staying in a society and my biometric is happening, that if I come and go, only my facial expression or my thumb impression can only be used to make an entry. That means no other than that, even my parents can't make an entry, and it is for this purpose, then it's okay. And they should also give me the details when I want to know that where you are using it, else it will be violative of this law. A clear notice containing the data collected has to be limited to the necessary for the specified purpose. That's why the specific purpose mentioned. A clear notice containing these details has to be provided to consumers, including rights of the concerned individual and the grievance redressal mechanism. Individuals have the right to withdraw the consent. So I do have a right that if I don't want this data to be provided, I can withdraw the consent. Is the ground on which data is being processed. That for what reason, for what grounds a particular data have been processed, I can definitely withdraw the consent. The law also creates rights obligation for individuals. These includes the right to get a summary of all the. Now what is that rights and the obligation? So the right is whenever I want, I can get a summary of all the data collected and to know the identities of all the other entities, organization with whom the personal data have been shared. If I want, I can ask them anytime and they hold a liability to do it. Okay, with the description, everything. Individuals also have a right to correction, completion, updating and erasure of their data whenever it's needed. We can do for it. So when all these matters related with Facebook using our data, Google using our data, India came with some strict rules in the Indian companies, in the ecosystem of Indian companies also. So that's why it was needed. Besides, they have a right to obtain redressal for their grievances and a right to nominate. Everywhere it is talking about one of the fundamental right, and right to information privacy is a part of this right. So that's why the law has given us so many rights within that particular law which was given. Chalo, let's move to question number 28, and the last 5 questions is this. An Indian company collects personal data from its users to provide personalized services. तो हम सबसे data company लेते ही हैं data. The company intends to share this data with a third party vendor for targeted advertisement. So they intend to share this data. Under the Digital Personal Data Protection Law in India, what must company do before sharing the data? Very simple thing. Without my consent, my data can never be given. Which option says? Yeah, it gives explicit consent from the users, makes it a right option. Rest all the other options might be indirectly would be meaningful, but this explicitly mentioned that what the company should do, they should take an explicit consent. Next, a social media platform processes user data based on the consent given during an account creation. That is normally happens when you create your own Gmail or Facebook or something account. A user now wishes to withdraw consent to process the data. Under the Digital Personal Data Protection Law in India, what must platform do? अब प्लेटफॉर्म क्या करेगा? जो भी हमारे यहाँ के लीगल रिक्वायरमेंट्स है फॉलो करें, क्योंकि नाउ वी नीड टू विदड्रॉ इट एंड वी डोंट वांट दैट पर्टिकुलर थिंग. ठीक है, सो रिफ्यूज टू एक्सेप्ट इज रॉन्ग. दे हैव टू फॉलो इट even though the consent was given, but now we can withdraw it. It's allowed. Comply with the legal requirements, stop processing the data is one thing. Continue processing the data but notify the user. No, they can't use the data because I don't want my data to be used. Allow withdrawal only after 30 days is extreme option. So correct answer becomes option B, because by elimination method you can do it. This somewhere become closer, not directly given in the paragraph. Chalo. A financial institution collects biometric data from its clients for verification purpose. If client wishes to know what data has been collected under the Digital Data Protection Law in India, what right allows them to request this information? So is it right to data portability, correction or to be forgotten, or right to access? Now basically we need to understand what is the question asking. एक फाइनेंशियल इंस्टीट्यूशन आपसे आपका डेटा ले रहा है. इट विश टू नो व्हाट डेटा हैज बीन कलेक्टेड, दैट इज व्हाट एवर डेटा यू आर यूजिंग फॉर द वेरिफिकेशन पर्पस. इफ द क्लाइंट विशेस टू आस्क अंडर दिस लॉ व्हाट राइट allows them to request this information. That means me as a citizen who is giving the data to the financial institution, what right which I have to ask them? Is it right to data portability? No, because when I am sharing consensually my data to the other person, I want to know about that data. That means I have access to that data. So I think right to access is the part. Right to correction is the one when you want to get it corrected. So this is not right. Right to be forgotten. So this is again a right which is being given, but in this context, under the digital protection, they want to know the data has been collected or not. That means the accessibility part talks about, and that is where option C becomes the right answer. Let's go to question number 31. So 31 talks about a startup provides a health tracking app that collects sensitive health data from users under the under the Digital Personal Data Protection Law. A lot of data happened. It's Digital Personal Data Protection Law in India. What additional precautions must the startup take compared to regular personal data? Now what they need to do it, they don't have to do additional measures are needed. So this is something which is very outrightly giving an opinion based thing ki no additional measures is needed, which does not make it a sense. Ensure explicit consent, adopt higher security standards is somewhere closer where there is consent and the standard need to be followed. Store data only when the with the government agency, so storing has no relevancy because it's not given to, that could be one of the part, but it's not given. Store the data only with the hospitals and other healthcare institutions, so this is very limitation because you need to definitely store it, but you need to do it with the consent of the person and adopting a high security standard. That's why B becomes a particular option, because you need to preserve the data. You need to even take the consent whenever you are sharing. So even though you are collecting all that data, with what additional precautions, consensually access being given to them, that is if they want an erasure and everything, so that's why it's being higher security standard need to be followed. Now the last question finally, and then we will end it up. So it says, as per the passage, what are the rights included under the original which is being under the digital data protection law in India as per the passage? Now these are the 6 rights which they have given. I'll just shift it over here. 6 rights are given, you need to choose a combination. So when I solved this particular thing, I just did the elimination thing that what it talks about. So first I'll understand. It says right to get the summary of the collected data is also a right. Right to know to whom the data has been shared is also right. Right to correct and update the data is also right, because everything in relation to this was given in the last paragraph. So you could have went there and check it. Right to get the data removed also. So erasure is also there to decide who can receive their data, and right to get redress of the grievances also. So don't you think that all these statements given over here is outrightly covered under my right to privacy and the data protection? So 1256 is also right, 1346 right, 1356 right. That means all statements are right. So, but there is na 3 or 4, idhar nahi diya, it is given. So we are saying 3 or 4 be correct hai, 2, 5 be correct hai. That means the answer is option D, because we say all the statements, all the rights given are correct. So that's the correct one. So guys, we have ended up over here. I know that it's a very lengthy video. You have to sit. That's why I have requested to watch this video at 1.25x pay. See all the explanations, and if you still face any doubt, please let us know. Till then, Siddhant sir signing off, and there are more videos under this series of Best of CLAT is coming. So wait for it. A lot many strategies, suggestions will going to be there. This would be your look up to playlist. Okay, chalo. Bye bye. Take care, and thank you so much. See you soon again.